Okay, everybody, we are ready to wrap up. So I hope we're all refreshed after our pastries and coffee. Thanks very much again for your continued presence. We've really excellent speakers this morning. 3 very different papers. We're looking at UPR first of all. We're going to again look at multinational corporations, and finally complicity into international crimes. And the theme of this morning's second panel is contemporary crises in international law and human rights. So as per the themes, the format I've gone so far, I have a finely crafted number 2 for 2 minutes and an X when it's time to stop. Okay, hand drawn this morning. I didn't have a yellow or red card, which I should have brought. And you have 15 minutes. So, Anna, would you like to kick us off? Thank you.
Hi everyone, my name is Amna. I'm a PhD student at Birmingham University, the School of Law and the School of Theology and Religion at the University of Birmingham. So I'm looking at the effectiveness of the Universal Periodic Review by analysing the extent to which the UPR as a transparent political dialogue is useful for the engagement of Islamic law with the death penalty. So one of the challenges facing the UPR today is whether it asks the right questions to Islamic states to engender productive discourse on the use of the death penalty with a view to its significant reduction at the very least. The Universal Periodic Review is an innovative mechanism of the Human Rights Council and was established in 2006 by the UN General Assembly Resolution 60251. It is a peer review mechanism that allows each member state to be reviewed periodically to assess compliance with its international human rights obligations and commitments. Such a mechanism is expected to combat the politicization and the selectivity that its predecessor, the Commission on Human Rights, was plagued with, and it would be the key factor in depoliticizing the human rights body. So the notion of universal scrutiny is the driving factor for success for such a peer review mechanism. It allows states to be subject to assessment by other members as well as stakeholders, and therefore prevents any single state from evading scrutiny. UPR Info assessed the progress of states during their first 2 reviews under the UPR cycle. The study found that a number of factors were crucial for state implementation. This included states' responses to the recommendations received, the nature of the recommendations, as well as their subject matter. The potential impact of recommendations on the human rights situation of a country varies depending on the quality of recommendations that are actually issued during that session. According to Edward McMahon, Category 5 recommendations, which require specific actions and demand certain tangible or measurable outcomes, are the hardest to implement, and the death penalty falls within such category. The abolition of the death penalty is one of the most non-implemented and least accepted recommendations in the Universal Periodic Review. The issue of the death penalty is presented as a recommendation to nearly every retentionist state, but has not achieved much success in regards to abolition. The status of the death penalty in international law is underpinned by Article 3 of the Universal Declaration of Human Rights, Article 6, 7, 14 of the ICCPR, and the ECOSOC safeguards, which provide for a very restrictive application of the death penalty with a view to eventual abolition. However, Islamic countries, which in this context will be countries whose constitution is largely based on Sharia law, are one of the most vocal retentionists when it comes to the issue of the death penalty. So let's take the Kingdom of Saudi Arabia, for example, one of the top executioners in the world. According to Amnesty International, it executed 102 individuals between January and June of 2015 alone. It's interesting to note that during its first UPR review, Saudi Arabia made no specific reference to its use of capital punishment, when submitting its national state report as part of the review process. On the other hand, the compilation that was submitted by the Office of the High Commissioner stated that treaty bodies such as the Committee of the Rights of the Child, the Committee Against Torture, all urged Saudi Arabia to review its legislation on the death penalty, particularly in regards to child offenders, confessions obtained under torture, and unfair trial proceedings. Similarly, a number of prominent stakeholders such as Amnesty International, the International Commission of Jurists, Al-Karama, they all brought attention to the government's use of the death penalty for a wide range of offences, including non-violent offences, and its extensive, continuous, and disproportionate use in defiance of international standards. It is important to note that civil society engagement in this UPR process brings independent and impartial perspectives, which are needed throughout the whole process in order to provide a balance to the state's performance. It also gives a voice to the marginalized and vulnerable groups, which highlight the universality and indivisibility of human rights. So going back to Saudi Arabia's review, during its first review, the Kingdom of Saudi Arabia accepted a recommendation to, quote, to protect the rights of those facing the death penalty, including through strengthened application of international safeguards in the use of the death penalty. But then when we go on to its second review in 2013, Saudi Arabia now dedicated an entire section in its national reports to criminal procedures, whereas in its first review, it didn't mention the death penalty at all. So this change is perhaps in response to its experience in its first review, where it received a number of recommendations and comments from states and stakeholders alike regarding its questionable use of capital punishment. And as a result, this has allowed for a more open and transparent dialogue to take place within the UPR process. Saudi Arabia stated that the death penalty is categorically provided for in Sharia law. It reiterated that capital punishment is imposed only for the most serious crime. Now, in order to effectively engage with the relationship between the Universal Periodic Review and the death penalty in Islam, it's also necessary to consider the status of capital punishment within Sharia itself. So the permissibility of the death penalty has been derived from primary sources of Sharia, the Quran, and Sunnah. The Sunnah is a prophetic tradition which has been compiled as hadith. However, the true extent of its application is contested by many scholars and academics, as the authenticity and history of hadith has long been a topical issue of debate. The Quran only has one version, but there are different versions and collections of hadith. Concerns about the validity of hadith have resulted in questions being raised about the application of fixed punishments, such as the death penalty, where there is an absence of scholarly consensus. Now, Islam and its criminal justice system contain a number of measures which are designed to preserve the moral values of society. And the Sharia categorizes criminal law into three types of crimes: Qisas, Hudud, and Nazir. Now, Qisas concerns offenses against the physical integrity of an individual, such as assault and homicide, and its premise is based on lex talionis, which is an eye for an eye, a tooth for a tooth. The word Qisas means equivalence, so the one who has been wronged is entitled to equal redress. However, the Quran also provides for victim forgiveness and restitution as alternative courses of action to this retaliatory principle. It should also be noted that Qisas category of crimes most closely reflect international standards on the application of the death penalty. Article 6.2 of the ICCPR provides that for countries which have not abolished the death penalty, sentence of death may be imposed for the most serious crimes. And most serious has been interpreted restrictively. The scope should not go beyond intentional crimes with lethal or other extremely grave consequences. However, the use of the death penalty in Islamic countries for offences which would not meet the standard of most serious crimes remains a concern in the international community, specifically for those crimes that are found under the category of hudud and ta'zir. So hudud literally means limits, and hudud crimes are defined as those crimes that are transgressing the limits placed by God himself. Their penalties, corporal punishment and death, are ordained in the Quran and Sunnah. Now there are 4 hudud offences that actually incur the death penalty. They are zina, which is adultery, rida, which is apostasy, baghi, which is rebellion, and hiraba, which is highway robbery. Now, the legislative policy behind hudud crimes is one of general deterrence. And in accordance with the prophetic narration, the Had penalty must be averted in the case of doubt. It has also been narrated that it is better for a judge to make an acquittal than a conviction in Hadith. There are stringent evidentiary requirements that must be proven beyond any reasonable doubt and should therefore be rarely implemented. And finally, ta'zir crimes are those crimes that do not fall within the scope of qisas or hudud. There is no mandatory requirement regarding the type of penalty that should be imposed. They are discretionary and subject to state legislation. Thus, as ta'zir is a discretionary offence, there is no bar to achieving the goal of abolition of the death penalty in Islam for those offences which come under this category. Penal Reform International has actually produced a publication that considers whether the abolition of the death penalty would be unfaithful to the message of Islam. And its findings actually show that Islam does not necessitate the death penalty, but actually provides opportunities to circumvent it. Similarly, William Shabas argues that although capital punishment forms an element of Islamic law, Islamic states fail to acknowledge the more limited role of the death penalty within the religious discourse. The interpretation of Islamic law varies from country to country, each displaying some degree of flexibility, but they refuse to acknowledge that the same approach can be utilized when it comes to applying the death penalty. Now, the Universal Periodic Review is a unique platform to allow such ideas like this to permeate through and engender such discourse. But whether this is actually done in practice is a completely different issue. So during Saudi Arabia's second review, it was noted that independent experts on extrajudicial executions, torture, and arbitrary detention urged the authorities to halt the execution of 7 Saudi nationals. The special rapporteur on extrajudicial summary arbitrary executions expressed concerns that the individuals were convicted of crimes that were outside the category of most serious crimes and after problematic trials. There were also concerns that the death penalty was imposed and was to be carried out following possible violation of the right to liberty and security of all 7 individuals. Mandate holders were outraged at the execution that took place on 13th March 2013, despite repeated calls not to carry out these sentences. The United Nations High Commissioner for Human Rights also strongly condemned the executions, viewing them as clearly violating international safeguards, repeating concerns as to the nature of these alleged crimes, confessions based on torture, and the insufficiency of these trials. The High Commissioner also noted that these individuals made brief appearances before the court, but were not given the opportunity to conduct their defense as the defendants claimed. The High Commissioner also reported that during its first UPR session, Saudi Arabia accepted a recommendation to protect the rights of those facing the death penalty, which does not seem to have been brought to fruition. The High Commissioner also noted that the death penalty applied to crimes not considered serious under international law, including drug offences, apostasy, heresy, sorcery, and witchcraft. So after analysing all these UPR documents that are involved in Saudi Arabia's review process, it becomes clear that there is a lack of discussion on the Islamic stance of the death penalty, which provides for a more restrictive application. The importance of repentance and forgiveness in Islamic discourse is highly emphasized, yet countries that apply Sharia law fail to give it due regard, which, I quote, can only be attributed to the selective application of the letter of the law, taken without regard for the Sharia's enlightened spirit. Other notable academics like Tariq Ramadan argue for an international moratorium on the death penalty in Islamic countries, as the application of the death penalty is conditional upon the state of society. Due to the absence of explicit or unanimous opinion by most scholars in regards to interpreting these texts and the application of these hudud laws, combined with the fact that majority of Muslim societies do not guarantee fair and equal treatment of citizens before the law, it is our moral and religious obligation to demand for an immediate moratorium on the death penalty. So by using the UPR, member states and stakeholders can challenge this monopoly of interpretation in Islam, which allows for a large scope of the death penalty and the regularity of its application. It is clear in general that the UPR ensures that all countries account for the human rights records in front of the international community. Paraphrasing Ban Ki-moon, the UPR has managed to lighten up the darkest corners of the world, by ensuring the review of every UN member state. The UPR has also made it possible to raise a wide range of issues on each country, including some newly discussed at the international level and some that are held as contentious, such as the death penalty. Yet it still has a long way to go to become the ideal mechanism that we want it to be. Thank you.
Okay, thank you, Amna. And next we have Samuel Ojogbo from the University of Nottingham. Samuel, thank you very much.
Well, the rate of forgive my PowerPoint will not be as sharp as the rest of seen. This presenter is on the go screen, as you can see. Having said that, this presentation is a small part of the broader research that is looking at alternative regulatory paradigm for regulating multinational corporations as against the general opinion of engaging them through international approach. And this paper is first going to look at the problem with regulating multinational corporations, especially in the developing world, because the issues of human rights violations by corporations is predominant in those jurisdictions. We're looking at the effects of the growing power and influence of multinational corporations, the lack of access to remedy in countries like Nigeria. Nigeria is the focus of this presentation, but I think it's representative of many developing markets where corporations violate human rights with impunity. Of course, aims and structure, we intend to investigate the growing power of, like I said, multinational corporations and the human rights implications of that power. We identify the interaction between human rights norms and business, and then examine the challenges. Look at the challenges this poses to human rights regulation. Multinational corporations, as you all know, as Luca has explained earlier on, have become very powerful, exceedingly powerful. And two things account for the challenge that it poses to existing regulatory regimes. One of that is the complex nature of their structure today. And you see, the corporations today, unlike the traditional corporation, which is just a single entity manufacturing simple items in given jurisdiction, they are not multinational. They operate in different countries. And some factors make this possible. One of such is globalization. It's easier for corporations now to operate from India and then open up subsidiaries in developing countries, maybe in Nigeria, Qatar, and every other place. But still control the operation from Western capitals. And it is the development in corporate law that actually made this possible. What are those developments? And how has it helped to encourage human rights violations? Now, like I said, corporations now operate in different jurisdictions, having headquarters elsewhere. This wouldn't have happened before the 18th century. Because when corporations started, like I said, they started from small undertakings. But the idea of corporate groups came after the guiding principles of corporate law has been in place. The guiding principles of limited liability and legal personality. We all understand how this affects. The purpose of these guiding principles were to encourage contribution and retention of capital to power economic development. But today, these same principles are used by corporations to establish legal entities in different countries. And they are also used to limit their liability against the victims whom they impact in those countries. As a result, there has been a mismatch between today's corporate structure and the legal structure on which they are supposed to be regulated. So, for this reason, there is already a discussion which has been going on that corporations in developing markets particularly should be regulated through international norms. That is, they are looking at international obligations of corporations under international norms. But the question is, why focus on human rights law and these universal standards? Why do we want to regulate business corporations using international norms? This question is particularly important because the activities that generate these violations that we talk about happen everywhere. Corporations operate in the UK, US, Germany, everywhere. But we're not talking of human rights violations in those places. All the discussions about human rights violations tend to concentrate in developing markets. So the important thing is to look at why is it then that these principles of corporate law, local regimes, are able to regulate corporations in these places, and they are unable to do it in other places. And to the extent that we now talk of international approach, international human rights approach to regulating business corporations, which have dominated discussions amongst the international human rights lawyers. Well, we must look at this idea of trying to use international norms from the beginning. We must look at the development. How did we come about it? Because regulating international human rights became a global was put on global agenda by the war, by the First and Second World War, particularly the Second World War, that saw to massive human rights violations and human rights and infringements on territorial sovereignty. So this is the point at which human rights that we know today began to develop. And so the idea was, like I said, the idea was to maintain, the idea of development was to maintain international peace and security. However, it was generally accepted that respect for human rights and fundamental freedoms is a precondition for achieving this idea of protecting territorial integrity, maintaining international peace and security. The fundamentality of human rights protection is reinforced in the charter that followed the setting up of the UN. And it says that the purpose of the charter, the purpose of the UN is, the purpose of the charter is to achieve international cooperation in solving international problems and in promoting and encouraging respect for human rights. The preamble to the Universal Declaration of Human Rights also states that every individual, you see, the idea about human rights is to protect the human person, the individual, against state action. And if you look at the UDHR, which was first endorsed, it's not a binding document, but we have the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, which followed the UDHR. These are binding, these are enforceable tabulation of rights that are enshrined in those instruments. For instance, most of right to life, right to health, and all the other rights are contained in these two instruments. In addition to these instruments, we have regional instruments like the European Convention on Human Rights, the American Convention on Human Rights, and the African Charter. But today, the rights that we talk about that are violated by corporations in developing markets are the same rights that are contained in these, that are guaranteed in these international instruments. So why do we still have these things the way it is, if these rights are guaranteed? The simple answer is that those who are supposed to comply with these instruments, especially those in the developing world, have not fully complied. They have not done the right thing. That is why, because if we say there is the right to life is guaranteed, it means that those who are supposed to protect these rights are those who are concerned, those who are addressed by these international instruments. And these international instruments address particular sets of international actors, particular states. As I say, without this, without doubt, international human rights instruments are devoted to recognizing the individual rights and corresponding obligations of states. Article 2.1 of ICCPR categorically states this. The reason for this, I've explained earlier, is simple. State actions were the actions responsible for the breach of human rights, massive violations of human rights and state sovereignty that happened, that caused the Second World War. But today, states are not the only participants at international scene. They are not the only ones who are there. But at this time, in 1945, there was no thought of cooperation violating human rights. And so basically, the idea of human rights law was to connect the individual to a responsible state. So now we look at how to protect the individual. But in 2016, corporations have become the biggest violators of human rights, especially in emerging markets. It's no longer the states that are doing more, and of course, they have greater power, like our colleagues have said earlier, than most states, and they have greater capacity to violate human rights. So what are we doing to get them to account for the rights that they violate? What has happened is that there's a subsequent evolution of UN powers to adopt policies or take measures directed at corporate responsibility for human rights, which is derived from the powers of the UN. And again, in addition, there's also what we're having to do, a broad interpretation of the rights enshrined in the International Bill of Rights. In citing this power, like Philippe has said, there has been development of international human rights obligations in international voluntary codes of conduct. The earlier speakers talked about the most prominent of them are the UN Guiding Principles and the OECD guidelines. All these regulatory regimes developed to ensure that corporations comply with their international obligations. So, in the context of a broader interpretation, of the existing norms, we have found that the UDHR states, for instance, which says that every individual, every organ of society should promote respect for human rights. These are interpreted to mean that every individual within a jurisdiction, including business corporations, must protect human rights. So the idea of this is, even the ICCPR, the ICCPR also recognizes private obligations in their preambles. So the problem with this, so I can get with it, is how do we apply these norms to multinational corporations? There's a problem. The voluntary codes of conduct like OECD guideline and the guiding principles are voluntary instruments, which the corporations are encouraged to comply with. So there's no obligation on them to comply with it. Secondly, the obligations that the broader interpretation of international norms specify clearly that states are still the primary duty bearers. So Article 2.1 of ICCR and Article 2 of ICCR clearly states this, and the international commission, that is like the African Commission on Human Rights, have clearly found Nigeria liable for not protecting the rights of the people. So the implication is that those implications that will lead to international norms as to the obligation of corporations still depends on the capability of states to apply those norms. But this is the problem that I have. These states cannot apply these norms because of the perceived weaknesses in their enforcement system. There is a problem, for instance, in Nigeria, where a case has stayed in the court for like 32 years. You know, that kind of regime is not a regime that is capable of dealing with issues of human rights. And again, there's continuous international litigation by human rights victims in international court, like the Bodo case, against Texaco, Jota against Texaco, and the rest of them. The lack of adequate access to remedy is a problem. So it means that it is impossible for us to rely on the human rights obligations of business. So to close that, so the idea, what we're doing in view of the fact that international instruments do not address multinational corporations directly, except the VCCs, which are non-binding. Realizing the rights enshrined herein depends on states' capability or willingness to fulfill their obligations in the instruments by providing access to judicial remedy for human rights, or alternatively, prevent the violations through legislative or administrative means. The weaknesses associated with legal enforcement institutions in the United States makes the remedial approach and thus the human rights approach an unviable option. Therefore, a legislative action which embraces preventive approach that is based on public participation in corporate decision making appears to be a more appropriate alternative because it will provide the opportunity for local community in emerging markets to hold multinational corporations accountable to human rights standards. Thus, further research is recommended to develop appropriate national framework that will provide the necessary platform for participation. Thank you very much.
Sorry to rush you again there. And the final speaker is Luca Ferro from Ghent.
So, good morning, everyone. My name is Luca Ferro. I'm a PhD student at Ghent University. Today, I will talk about complicity in international crimes through arms transfers. But as you can see, I've sort of tweaked the title of my presentation because I always go looking for a short catchphrase that makes clear what I try to convey with my presentations with brothers in arms. And for anybody who doesn't really get what I'm talking about, I put in a very long subtitle, so it's clear regardless. And so do state responsibility and accessorial criminal liability for arms transfers to international criminals. Let me just start with a very short case study. I have chosen South Sudan because there were two UN panel of experts reports that made very clear the point that I wanted to get across. First of all, if a non-international armed conflict is taking place, the continued influx of weapons to either party of the conflict actually prolongs and escalates the conflict as such. And second of all, that influx of weapons usually, or more times than not, has a devastating impact on civilians in particular. And I chose South Sudan, but I could also have gone with the Yemen case study or the Syria case study or any non-international conflict taking place. My presentation, since I only have 15 minutes, or probably 13 or 12 after a long introduction, will focus on three small parts. So first of all, ancillary or secondary state responsibility, so complicity on the state level. Second of all, accessorial criminal liability or criminal liability complicity on the individual level. And then finally, since we're talking about interstate arms transfers, so state A providing state B with weapons that are then used to commit international crimes, to see whether or not there is a link between one and two. And I hope it will become more clear during the rest of my presentation. So let's start with a small quote to get running. Responsibility is a detachable burden easily shifted to the shoulders of God, fate, fortune, luck, or one's neighbor. In the days of astrology, it was customary to unload it upon the star. Basically, nobody wants to take responsibility, especially for arms transfers in this scenario. It's a legal presentation, so as one of my colleagues yesterday said, we should start with the legal definition. Article 16 of the Article on State Responsibility deals with secondary state responsibility. And in short, it says that a state can be held complicit if it aids or assists another state in committing an international wrongful act, if it had knowledge of the circumstances of that internationally wrongful act. So two elements that we have to keep in mind. First, aiding and assisting, which is significantly or substantially contributing to the wrongful act. Two, with knowledge of the circumstances of that act. Now, when you go and read the ILC commentary, it adds a third element basically to the legal framework. And it says not only should the assisting state be aware of the circumstances making the conduct wrongful, basically state A that knows that state B will commit international crimes with its assistance, but it must also intend to do so. So basically state A must provide state B with the weapons for the purpose of facilitating these international crimes. So it really adds a volitional requirement, it adds an additional requirement to this framework. Now, not only do I think that this is probably morally wrong, but like Professor Tsanopoulos yesterday said, that doesn't really matter, my opinion doesn't matter. I also think that legally, it doesn't hold up. And I have three small arguments for that. Well, I mean, we can talk about this later if you want, but for the purpose of this presentation, first of all, draft versions of Article 16 included such an intent or purpose requirement, and they were not agreed upon. It was not included in the final draft of the article, which should already make the point quite clear. Second of all, we had the ICJ Genocide Convention case in 2007, where the court first of all said Article 16 is now customary international law. So the argument that it was a measure of progressive development and should therefore be interpreted narrowly no longer holds up. And second of all, when the court looked at the argument that Serbia potentially was complicit in committing genocide in Bosnia and Herzegovina, the court said, well, to look at this question, all that is required, or at minimum what is required, is full awareness of the fact that the VRS, or the Army of the Republika Srpska, would commit genocide. So they should have just known, not intended to support the VRS to commit that crime. And then finally, the third argument, why only knowledge and no intent, is that the Arms Trade Treaty, or at least Article 6.3, specifically says so. And it says basically that states should not authorize an arms transfer if it has knowledge at the moment of authorization that these weapons will be used in the commission of all types of international crimes. So what should you take from this? Secondary state responsibility. You have two requirements. One, a substantial or significant contribution. Two, with knowledge of the fact that your weapons will be used to commit international crimes in the future. Second element, accessorial criminal liability, complicity on the individual level. Another quote, it is psychologically easy to ignore responsibility when one is only an intermediate link in a chain of action, and perhaps this is the most common characteristic of socially organized evil in modern society. Again, it's sort of similar like the first quote. Everybody says, I'm only a link in a chain of evil action, so you have to look at somebody else for real responsibility, whereas everybody in the link shares the responsibility is the point that I try to get across. Again, time restrictions, I need to sort of summarize the argument. So if you look at the jurisprudence of the ad hoc international criminal tribunals as it stands today, what is required for aiding and abetting is again an objective element, namely practical assistance which has a substantial or significant effect on the realization of the crime, which has been given with knowledge that these acts assist the commission of offense. Again, substantial or significant contribution with knowledge of the fact that it will help commit international crimes. Now, as far as the Rome Statute goes, strangely, Article 25.3c, when it talks about aiding and abetting, added this purpose or intent requirement. And so, under the Rome Statute, aiding and abetting requires more than simply knowledge. However, Article 25.3d2, I mean, it's very late in the multi-liability article, but it's still there, still criminalizes any kind of contribution to a group with a common purpose that then commits international crime, as long as you have knowledge of the fact that your assistance will be used to commit a crime. So under ad hoc jurisprudence and under the Rome statute, significantly contributing to an international crime with knowledge of the fact that your assistance will do so is criminalized. And so we see that the elements very much overlap, both in state responsibility and in international criminal law. And again, we have three cases, in fact, that were decided. The first one is the General Perisic case at the ICTY, the second one, Charles Taylor at the Special Court for Sierra Leone, and finally, quite recently, the German Katanga case at the ICC. And the red thread throughout all of these cases is that all of them, well, for General Perisic, it's a different story because he was acquitted on appeal based on the specific direction requirement, which didn't hold up in the case, but we can talk about that again later for those who want. But the red thread is basically that providing an on-state armed group or an army of a state with loads of weaponry, so flooding that country, your ally, with weapons, knowing full well that they will use them to commit crimes, actually leads to accessorial criminal liability. For example, Charles Taylor was convicted on appeal. It was confirmed to 50 years of imprisonment for this type of assistance. The same goes for Jermaine Katanga, although there was a scathing dissent by the Belgian judge, Judge Christine van Wengaert, but again, nobody appealed the judgment, and so the judgment as such still stands. So what is interesting to me in this particular case is that since secondary state responsibility and accessorial criminal liability, those elements really overlap. Now, what happens if the state authorizes arms transfers and the state official specifically involved, how do then state responsibility and criminal liability interact with one another? And you can look at it from two different perspectives. Again, a quote by the United Kingdom, because it's a conference in Liverpool. All government should always be held responsible for all acts committed by their agents by virtue of their official capacity. So basically, a state can only act through its agents. So if the agent is criminally liable, then the state incurs state responsibility. This is Article 4 and 7, basically, of the Articles on State Responsibility. You can look at that if you want. What it comes down to is that the objective elements, the objective and mental elements of complicity are analogous. I said that already, significant contribution and knowledge. If the state organ then acts in its official capacity, it is always an act of the state. And therefore, if we can hold a state official criminally liable by an international criminal tribunal, linea recta, secondary state responsibility follows. And before you say, well, this is a theoretical sort of debate, it's not really the case because Charles Taylor at the time was president of Liberia when he was criminally convicted for aiding and abetting. General Perisic, although he was acquitted, was also one of the most senior officers in the Yugoslav army at the time. And so his acts, because he acted in his official capacity, were linea recta attributed to the state as such. So if he's criminally liable, the state incurs secondary state responsibility. Now the opposite discussion is a bit more problematic, obviously. Let's assume that Serbia was in fact convicted for complicity in genocide in the Bosnia-Herzegovina and Serbia case of the ICJ, which, to be sure, it was not. But four of the judges dissented and said, well, in fact, there is enough to go on to say that Serbia was in fact complicit. What would that mean for the state officials that were involved and actually authorized the arms transfers? Because the state, as I said, can only act through its state's agents. And now, if the state is held secondarily responsible, and because of the fact that the elements are so analogous, my argument is that at least it informs, it simplifies prosecutorial strategy in that it targets a group of state authorities that are flagged collectively, basically, as being complicit. And so if you read the dissenting opinion of Judge Keith, for example, he said, well, since Milosevic knew Serbia should be complicit under Article 3E of the Genocide Convention, and so he immediately points out particular state officials that should have been aware or involved in authorizing these arms transfers. And so my main point basically is that, which is not really followed by most scholars, I have to say, but is that in states, secondary state responsibility and accessorial criminal liability, the elements are the same, and therefore interstate arms transfers that contribute to international crimes, so let's say US or UK support to the Saudi-led government, the Saudi-led coalition operating in Yemen, or Russian and Iranian support to the Assad regime in Syria. All of that, at least we should keep an eye out for secondary state responsibility and perhaps even individual criminal liability as well. Thank you.
Thank you very much, Luca. Three really excellent presentations. I'm sure we've got lots of questions. We've got plenty of time until 25 past or so. So, any questions on the floor? Yes, in fact.
Luca, thank you for a great presentation. You mentioned that you are a minority there. I was wondering if you could elaborate on what the majority says about this. I tend to agree with you that it feels artificial that when the SCJ finds that there is mistakes with, for instance, in the genocide cases, for instance, in Bosnian Croatian genocide, the SCJ comes to a very different conclusion. Sometimes, same in Bosnia, and the attribution standards are different. The mens rea element is substantially higher in the SCJ forum. So, if you could elaborate on that, pinpoint the flaws in their approach to your question.
Before Luca jumps in, we'll take another couple of questions. Thanks very much for that.
Thank you very much. Thanks for your presentations. My question is for Samuel. I think it's very good that you bring the idea of the very structure. I think it's very refreshing in this area. We're just wondering, maybe you didn't have time to go through it, but if you have any means to consider how you would ensure that corporations take the process seriously. I do feel that this kind of access from other stakeholders already exists. For example, the National Fund, the OECD guidelines, they can sit together and discuss. But there have been some cases where the corporation just doesn't take the process seriously. The means ultimately to
One last question.
Thank you very much for really interesting presentations, presentations as well. My question is that I'm really enjoying the survey sort of excitement, just thesis. So I think using such as line of law is a really sort of interesting idea, and you said that the UPR uses the initial rationale behind the UPR might be towards the equalised human rights institutions. Obviously, equalisation was one of the sources of criticism that led to the former Commission of Human Rights and Social Society in 6251. Just trying to say that the universal peer review to universalise and to equalise at the same time seems to me to be a bit of paradox. When we universalise, this in itself is a sort of political decision. And whilst your case example of the death penalty might be immune from this argument, because there might be something, surely there is something universal about the prohibition of the death penalty. But in those cases, is there any other examples of universal peer review whereby Human Rights Council may be trying to universalise aspects of Islamic law in a way that maybe are a bit more problematic?
Okay, thank you very much for all those questions, and they neatly fall in one panelist. So, Luca, do you want to start with the question about the alternative arguments and why they perhaps don't hold water?
So thank you very much for an interesting question. But the majority opinion, and I mean, we're talking about very eminent legal scholars like James Crawford, there are many, they still seem to think that, or they still argue that secondary state responsibility requires both knowledge and intent. And they say in the commentary, and they refer back to state opinions and so on, this measure of progressive development argument keeps coming back, and they say, well, we shouldn't open up secondary state responsibility too much, because it can lead to, as we can see, it happens quite often in practice, and it could also mean that if state A supports a fight in state B that most of the world agrees with, that they could still be held secondarily responsible if crimes are committed, which is often the case. I mean, you often support a group that does lawful acts of war, but also maybe on the side, maybe not in the majority, but also commits war crimes as well. And so should that mean that if there is a risk that that might happen, that all state support immediately leads to secondary state responsibility. And so to avoid that overbroad, let's say, liability for states, they say, well, keep intent in here. Now, legally, I don't think that holds up. And second of all, I also think that the knowledge requirement in and of itself provides a very high threshold, because it really means sort of virtual certainty that your assistant will lead to the commission of international crimes in the future. And to me, that's already quite high. It's very hard to predict what will happen in the future, but you need to be almost positive that serious risk of international crimes is not enough, not even according to the ICJ in the Bosnian genocide case. So I don't really see the problem, but I see that they're trying to find loopholes, the specific direction requirement, Perisic, or intent for secondary state responsibility by the majority of scholars. Now, as for the dichotomy between the ICJ and the ICTY case, well, I mean, it's problematic in the sense that they're dealing with different aspects. One is dealing with state responsibility, and one is dealing with criminal liability of a particular individual. Now, that being said, I find it very hard to believe that if the ICTY would have convicted Perisic, saying that he had knowledge of the fact that his assistance would be used to commit crimes, that the ICJ then afterwards would not have convicted Serbia for complicity under genocide. So because of this specific debate that happened there, and because the ICJ decided on the case before Perisic came to why in fact, this perhaps explains whether the economy is such. But as I said, 4 of the judges dissented, and so let's see if another similar case comes to the ICJ, how they respond.
Thank you. I'm going to respond to the question about how we can ensure corporations take the process seriously.
Yeah. If you listen to what I talked about corporate structure, of course, one of the many problems why we are now talking about international regulation for multinational corporations is because of the national laws have domestic focus. So each state must look at its corporations within its jurisdiction. And of course, even though Shell in Netherlands and England own the Shell that operates in Nigeria, we cannot, the problem is because of the principle of legal personality, we cannot hold Shell abroad responsible for what Shell in Nigeria is doing. So now, that is the basis for development of these international standards, like the OECD guideline. But the problem I try to emphasize is that such guidelines like UNGP and OECD are voluntary instruments. They are soft law instruments. They have no binding authority. If you talk about national contact points, the OECD guideline is clearly stated that it is non-binding, it's voluntary. It is very clear. And the contact points do not have no authority to pronounce on the liability of the corporation, even though they exist. They have no authority. So that's the question. That's why this research is saying that these voluntary approach to regulating, like expecting them to self-regulate, but that's what it is, does not work well for the problem of human rights, corporate human rights violations in developing countries. And that is why we are looking at state-based approach to regulating them. And again, that's why we also say that even the enforcement capability of emerging markets makes it also impossible to rely completely on command and control legislation, like you do this, we find you, we send you to do, and all of that won't work because the courts are inefficient. I just mentioned one case of a case in Nigeria involving Shell and Chief Amna was in court in Nigeria for 32 whole years. During this period, I'm sure that the man who started the action would have died, and possibly his successors entitled are those who concluded the investigation. So these are the kind of problems that make human rights victims in this region to look up to the courts in England and US under the Alien Claims Act. So if you, yes, national contact point, yeah, that's a point, that's a place where we can look at what this corporation has done. That is, like I said, they have no authority to determine the liability of the corporations. So to that extent, I am saying that these new approach of international obligation of looking for international obligation of corporations is not a very good approach because all of these approaches are envisage remedial solutions. And if we go back to international norms, they are looking at the obligations of corporations cannot be, the solution cannot be only remedial. It also says that it could be resolved through legislative or administrative means. And I'm advocating legislative means, which is state-based, which must look at other areas of international norms, to look at preventive measures, which international human rights norms do not envisage.
And finally, Amna, can you address the question that Ben?
Yeah, it's a good question. Thank you. Regarding the paradox between politicization and universality, I do agree with you. It's actually quite difficult to remove politicization completely from anybody. But I think at the moment, compared to what we did have, I think the UPR is the best that we currently will have at the moment. An example of politicization, for example, with the UPR and how it was combated was initially during its first cycle in the early days. What happened is that when states would want to issue recommendations for states under review, they would have to put their names down on a list. And what would tend to happen is the state under review, its allies would generally quickly get their names down in the beginning. So the countries that would be speaking would only be the allies, and they'd use up most of the time issuing statements of praise, saying, you know, your human rights are fantastic and everything's hunky-dory, lovely. And then other states wouldn't get the chance to actually issue concrete recommendations and say, well, this is your best practice. However, this is where, you know, you're going wrong, something should be done here. And the way to combat this is now they're using the process of random selection. So all the countries that want to speak and issue a recommendation put their names down, but then there's a process where they are randomly selected to avoid this sort of politicization that does occur. In regards to other areas of, I'd say, Islamic law within the UPR, I don't know anything on the top of my head, but there is, I mean, one issue would probably be women's rights, which is normally contested in the UPR as well. A lot of Islamic states are encouraged to ratify to the CEDAW Convention because a lot of them do tend to have reservations. So, I mean, that is one area that has come to my mind, but I haven't actually researched into it too much to know exactly.
Thank you, Anna. Any more questions? Yes.
So, Luca, thank you for the presentation. I would like to know, how do you think that the arms trade treaty that it was forced in 2014 can contribute to the discussion and contribute to allocate responsibility to the states and also to reduce illegal commerce, illegal trade of arms?
Take any more questions as well, Josh?
My question is for Samuel. I wonder if you can sort of elaborate a bit on this idea. I think when I was speaking about this idea of participation in the structure of cooperation, like public participation within the decision making. So I wonder if you could elaborate a bit more on that. That sounds kind of interesting. Whether that would require like a change to the laws of incorporation, or whether this would be less of a legal change, more of an operational change.
Do we have one final question to wrap up the trio? Yes,
I have a question for Samuel, actually. Do you consider that multinational corporations are directly or can be directly bound by human rights law? And if so, instead of being bound through national and domestic laws? And if so, why? What would be the reasons to this?
No, I don't get it. Yeah, they can be bound.
If they can be bound directly from human rights law instead of going through domestic jurisdictions.
Okay, let's start from the order they were asked in. So maybe, Luca, if you want to address the question that was raised about the Arms Trade Treaty of 2014.
Again, thank you for your question. So I think the Arms Trade Treaty is a very big step forward in the sense that it now also puts in a primary obligation on at least the states parties to no longer authorize weapons transfers in case of knowledge that they will be used to commit international crimes in the future. And actually, if you look at the French or the Spanish version, it doesn't say will be used, but can be used. So it's actually even more broadened as such. So it's a primary obligation for states parties. But the way that I used it is also to enforce my argument, to sort of support my argument that it's knowledge and knowledge alone that is sufficient for secondary state responsibility as well, because they only talk about knowledge in Article 6.3, and again, they try to put in purpose or intent in one of the original drafts, and everybody, and especially under influence of civil society, sort of took it out, and now we're left with knowledge alone. And so it falls within this new modern evolution of more and more state practice, where also in some judgments at the ILHRU, states have been convicted for assisting, for example, acts of torture. I think in the Poland cases, 2013, if I'm not mistaken, merely for assisting while knowing that the CIA was carrying out extraordinary renditions on its territory and torturing terrorist suspects thereupon. So it imposes primary obligations, but it also supports the argument that mere knowledge is enough for secondary state responsibility and, by extension, for individual criminal responsibility.
Thank you, Luca. And Samuel, the two questions that are directed.
Yes, I'll take it in further into there was asked. Well, one asked me to elaborate on the public participation, whether it will involve a change in corporate law. I think yes. Why do I say so? Because I talked about the mismatch between the current corporate structure and the principles that guide corporate law. For example, the guiding principles of corporate personality were not intended to shield corporations in the first place. They were intended to shield the assets of the corporation, statute, from the liability of contributors. And limited liability was to limit the liability of contributors, to encourage contributors to put money into the corporations to empower economic development. That was the purpose. But beginning from about in the 1880s, when the American courts decided, talked about, the state of Georgia came up with the legislation that allowed corporations to take shares in other corporations. That sort of defeated the original intention of the legal personality principle. Now corporations own shares in corporations. And globalization has compounded this. Because now it is not only about corporations in England owning shares in corporations in England. It now involves corporations in England or the USA or Germany controlling corporations in the developing world. And of course, in the case of Adams and Cain, it was very clear that the judge was clear that even if those those corporations, those subsidiaries, were established as special purpose vehicles to evade liability, they are still legal persons anyway. And so you cannot bring the acts to bear on the parent company. So to that extent, we are thinking, and if you look at that, and then look at the development on the international scene, and look at enforcement deficiencies in emerging markets, then that is why we advocate a new regulatory approach, the one that embraces public participation. And as I said, international norms did not envisage that. Public participation is in public law. In under international, I think is Article 19 and 25 of ICC. I talk about participation in voting to elect your leaders and all of that. But there is no such for private sector. And the only places we can find public participation for public sector is probably in international environmental law. So looking at the new declaration that talks about public participation. But the question is, for another day, is whether that particular instrument, the operation of that instrument in these developing economies sufficiently protect those whose rights are violated.
So we have about a minute left. So if you want to summarize
So-
your answer very quickly, and then move on very quickly to the second.
So basically, what we are saying is that it will involve a change in corporate law to bring about, because corporate law is the law that that regulates decision making inside the corporation. So I think that we're looking at the corporate law approach, but that does not take us away from looking at the foundational framework upon which that can be built. That's why we recommended further research on that. And on whether multinational corporations can be bound by international human rights law, the answer is clearly no. Yes, if you look at it on the surface, because we just talked about the preambles to the UDHR, ICCPR, and ICLHRU, talking about the obligation of individuals. Every individual within society, which includes corporations, yes. But the problem is, can we say that such provisions put obligation on corporations in the true sense of the word? I don't think so. Because if you have to enforce an obligation against an entity, you must be able to take the entity to court for the enforcement of the obligation that is supposed to people. But in the case of international human rights law, the obligation on corporations depends on nation states. So the states are the ones who are the ones that will ensure corporate good behavior. As in the case of Turkey and the civil war, this European Court of Human Rights was there. That even the act complained of is the act of a private organization. The state is the one that has a responsibility to deal with it. Thank you.
Okay, that's where we'll have to leave it. Thank you very much to our panelists, and we give them a round of applause too. Thank you very much. We've now got a lunch break. How long would you say? 45 minutes to get back on track, perhaps?
About 50 minutes.
50 minutes?
Yeah, 50.
Okay, and just to remind you as well, the posters from day one are still available